Live? Okay, thank you. So it's 11:02, January 9th, Senate Judiciary. We're going to be talking about S-196. And I'll just give a general overview and allow others to dive deeper into the details. So, you know, as we discussed last week, 7553A hearings are one of the types of hold without bail hearings that we have here. And what I'm trying to change specifically with this bill is to change or clarify what forms of evidence are able to be introduced for the second phase of these types of hearings. So, you know, with the first part of these hearings, the state has to show that there's likelihood that the guilt is great, and you know, the rules of evidence do not apply to that first section. Now, the second part requires that the state prove that the defendant poses a physical threat of violence and that no combination of conditions of release will reasonably prevent that violence. And for that second phase, you have the clear and convincing evidence standard. And the genesis of this bill was from my Windham State's Attorney's Office, but basically from what I've been hearing is that there is a discrepancy between a number of judges as to how this second section or this second part is interpreted. So what I mean by that is some judges are requiring live testimony, whereas others are not. And so what's happening is that, you know, within days or just a few weeks of an assault, for example, the victim may be required to testify in front of the person who is charged with that crime. And whereas other judges interpret it to think that the victim does not need to testify in person and that they can rely on affidavits and other evidence from the scene. So the purpose of the bill, or rather the language of the bill, is on page 2, and it's just 2 sentences which states that that the rules of evidence will not apply to this second part. And you know, this is not anything new or groundbreaking. The rules of evidence already don't apply to the other types of bail hearings. And this just puts specifically 7553A hearings in line with the other types of bail hearings. So I'll just leave it at that as the general overview of the bill, and I'll pass it over to Ben from Ledge Counsel to give us the walkthrough. Or actually, are there any questions for me? Okay. Ben.
Thank you, Senator Sheem. For the record, Ben Novogrovsky from the Office of Legislative Counsel. Just piggybacking off of what Senator Sheem said, this bill is it's S-196, an act relating to the types of evidence permitted in weight of the evidence hearings, and it proposes to ensure that weight of the evidence hearings proceed in the same manner and with the same evidence that's permitted in other bail hearings. Specifically, this bill proposes to permit evidence through sworn oral or recorded statements that can be used in addition to live testimony. So it wouldn't necessarily be restricting any use, it would just be sort of expanding it. This language is actually also contained, not in the exact form, but the substance of it is contained in 7554G. Those bail hearings, the rules of evidence don't apply. So to get into what 7553A hearing is, typically referred to as a weight of the evidence hearing, and this is when the state must prove evidence supporting the felony charge, demonstrating that the likelihood of guilt is great. So if the state makes such a showing, the hearing proceeds to the next stage where the state must prove that the defendant's release poses a threat of physical violence and no combination of conditions will reasonably prevent such violence. So this is all a hold without bail situation. That is sort of the starting point of this. So for the first showing, the Vermont Supreme Court has held that in a weight of the evidence hearing, the prosecution must establish that substantial admissible evidence of guilt exists and that the evidence can fairly and reasonably convince a fact finder beyond a reasonable doubt that the defendant is guilty. So that's what we're talking about was sort of what I alluded to before, is that we're talking about someone's liberty interest prior to an adjudication of guilt. So that's why this standard is higher. We're talking about, a reasonable doubt standard almost, as far as what the type of evidence that exists out there. And the court has said that this is shown by affidavits, depositions, sworn oral testimony, or other admissible evidence. So once the state meets that showing, the Supreme Court has opined on the kind of evidence establishing that the defendant's release will pose a threat of violence and that no conditions of release will reasonably prevent it. That includes history of violence towards the alleged victim, the quality, quantity, and scope of violent behavior, whether the defendant's conduct is based on powerful emotions so that they won't be able to follow the court's directives, and whether or not they have a history of violating court orders. So normally in these hearings, since the rules of evidence apply, evidence must be relevant and reliable to be admitted. So oftentimes you may get somebody, so for instance, if you don't have the rules of evidence applying, you can essentially make the argument and present any evidence. It doesn't have to necessarily be reliable. And reliability can be determined in a multiple of ways. Like, so for instance, Senator Sheen, we were talking earlier about the responsible adult. Now, granted, that's in a different situation, but you could put someone on the stand. You could put them under oath, and then they have a sworn testimony in court that's immediately reliable because it's an in-court statement used to prove the truth of the matter asserted. Hearsay is when you're trying to use an out-of-court statement, which has an inherent reliability attached to it. So what this would do is negate that requirement, or at least the perceived requirement, that someone needs to be sworn under oath to testify to something in a weight of the evidence hearing, that it can be submitted through an affidavit. I think, as Senator Sheen had alluded to, a lot of this is done in the DV context, and as you'll see in the Windham County State's Attorney's memo, it talks extensively a lot about the trauma and how that could be a negative experience for victims having to come into court and testify again about the incident. So that's what this is attempting to avoid, is to provide other avenues to get that evidence in so that the court can then make the determination as far as the public safety protection analysis is concerned. Any questions about
Senator?
Thanks, Ben. I'm looking at page 2, and what I hear you saying, and the Vice Chair saying, is that the idea is to allow for affidavits and non-in-person testimony for good reason, as was explained. When I look, it says need not conform to the rules plural, pertaining to the admissibility of evidence in a court of law. And I'm wondering, is that a more broad-based thing that we're doing than just appearing by affidavit, et cetera? Are we making things that were previously inadmissible, are we making things that were previously inadmissible, admissible in addition to appearing by affidavit, et cetera? Does that make sense?
Yeah, well, I mean, in this context, yes, but in the context of all other bail hearings, that evidence is already permitted.
Understood.
Yeah.
But so in other words, we might be okaying other sorts of things to come in via this language other than affidavits, et cetera.
Correct.
Okay, so then my only question would be, what does that universe of things look like that we are now making admissible through that sentence?
Well, I would defer to my colleagues and the state's attorneys that, or the boots on the ground that can testify to this. But I think a good context for this is We're talking about the second part of that analysis.
Yeah,
Where it's the combination of conditions and which one, because the kinds and form has been determined in that first part of the analysis where guilt is great. This is then where it goes into that public protection and reasonably protecting the public. That's where we're
Yeah.
talking about it. So it doesn't, just to keep that in mind.
yeah, I guess, and maybe it's a necessary thing in the drafting, but ordinarily, if you wanted to make affidavits, let's say, admissible, you would have wording that says affidavits are admissible. But here, we're saying that all of the evidence that was previously inadmissible is now admissible.
Right.
And I'm not an expert enough to know what that scope of things looks like.
And that language was specifically used because it existed in 7554G.
Yeah.
The only difference between the two is the last sentence, and nothing in the subsection shall be construed to alter the existing standard applied to determine whether the evidence of guilt is great under the section. And that's because it's unique to this statute.
Yeah. So that was my only question about the drafting of the way we're accomplishing what we're trying.
Thank you. And I was wondering, I appreciate the question, Senator Ruth. The question that I have, that if you're able to talk about it, that would be great. The types of evidence that can come in if this rule change is made. And, it's not, from my understanding, you can't just bring in absolutely anything. There is the case State versus Lesage, which, my understanding is that it requires if hearsay is being brought in, it does have to be reliable or credible. And so that's just one component, but are there other rules or cases that come to mind regarding what types of evidence can be brought in when the rules of evidence don't apply, similar to how it is with all the other bail hearings right now?
Right. I mean, I think at the outset is that since the rules don't apply, it wouldn't have to necessarily be. I mean, you'd hope it'd be relevant because that's, otherwise it might be a waste of time, but it wouldn't necessarily have to be reliable. So for instance, let's say, in a DV case, maybe there was a report done, outlining the alleged abuse, right? But normally you'd have to bring in either the author of the report to testify to it so that they have personal knowledge, or someone that can say that these types of reports are sort of standard business records that were made at the time, at or near the time of the event, that the person, there are other sort of reliability factors that go into that. With this, you could just put that up there and talk about it. You wouldn't necessarily need to get the author of the report to testify to the report's authenticity and reliability. So it could get in through another means. You could just offer the report. You could potentially question somebody else about it without establishing its reliability first.
Okay. Thank you.
So we're not just talking about alleged victims in this crime. We're talking about anybody who wants to give testimony.
Yes, it does not exclude anybody.
And one clarifying thing. So a victim can still testify, correct, if they wanted to, right? They're not.
Yes.
But rather what this is doing is making it clear to some judges that there's not a requirement that there's live testimony, within the 15-day window, right?
Correct.
Okay. Thank you. Anything else from the committee? No? Okay. All right, great. Thank you, Ben. All right, so next up we have Dana Nevins, who's joining us from Zoom.
Morning.
Morning.
So my name is Dana Nevins. I am a deputy state's attorney here in Windham County, and I just wanted to provide a little bit of history about why I'm testifying here for the department today. So I have been the domestic violence prosecutor for about 5.5 years. During that time, I've handled over 1,000 domestic violence related crimes, domestic assaults, violation of abuse prevention orders, stalking, related conditions of release, prosecution. And over 300 of those cases have involved felony of one sort or another. And I think during my time, I've done an approximately 60 weight of the evidence hearings for hold without bail cases. And the vast majority of those have been 7553A hearings. I think Tim told me yesterday that I've been the DV prosecutor longer than anyone presently serving in that role in the state. So I'm going to talk very much from the DV perspective because that's my expertise, and those are the majority of hold without bail cases that arise under 7553A. And I might use some gendered language because most of the cases arise with a male offender and a female victim, but I'm not meaning to imply that that's obviously the only scenario. So I want to talk about why this legislation is important and use a case that I worked to really illustrate this. So we're talking about the police being called to a felony domestic assault. So we're in the realm of 7553A because we have a felony crime of violence. And I'm going to use an example of someone I'm going to call Sean and Cindy. So a neighbor called in this case because they heard a woman screaming. And so the police arrive, figure out who's involved, and collect a sworn statement from Cindy about what happened. So Cindy tells what happened, and then they ask her, does she swear under the pains and penalties of perjury that what she told them was the truth? And as part of that investigation, and through these types of investigations, either formally or informally, police will generally ask about history of abuse, history of threats, history of controlling behavior. And in Windham County, they complete a domestic violence packet that leads them through some of that questions. So Cindy talks about the history of abuse in the relationship. And so this is Cindy's first time talking about this information. This is her first time having to tell this information. So Sean is arrested and held overnight after the police consult with a judge. And then an arraignment happens. If it was a weekday, it was the next day. If it was a weekend, it's Monday morning. And so we review the case and make a determination if we're going to request a hold without bail under 7553A. And in this case, because of the facts and because of the history of abuse, we did. And Sean is held, and the court also imposes conditions of release to don't contact Cindy. So the court sets a weight of the evidence hearing, and they will set this weight of the evidence hearing within 2 weeks of the arraignment, but it could be within several days. I've done them, I think, within 4 days, but 2 weeks is the later end of things. And so as I review this case, I see some loose ends, and I have an investigator follow up with Cindy. He actually collects some recordings about defendants admitting on a recording to assault him in New Hampshire. And she also talks about a call she got from the correctional facility where Sean called her up and told her, please don't testify. Please don't testify against me. And we were able to get a court order to get that recording. So now we're at the weight of the evidence hearing. And during that first stage of the hearing, we are able to play Cindy's recorded statement to establish that Sean strangled Cindy, to establish that we have evidence to show that Sean strangled Cindy. And that stage proceeds sort of the same throughout the whole state. Now, the second stage of the hearing, when we need to show by clear and convincing evidence, which is a very high burden, that he poses a risk to other people, at least one other person, and that no condition or combination of conditions will mitigate that risk. That part of the hearing is going to proceed differently depending on which judge you are in front of. Some judges say the rules of evidence apply, and some say they do not. So if the rules of evidence don't apply, we could use Cindy's recorded statement about the history of abuse to establish that history. We could use her sworn recorded statement to establish that the video of Sean admitting to an assault in New Hampshire against her was authentic. And we could use her recorded statement to establish that that phone call where he's already violating conditions of release and telling her not to testify is authentic. So I was in front of a judge who ruled that the rules of evidence did apply, and I did not have Cindy testify. And so the court ruled that all that evidence that I had, her statements about the history of abuse, the recordings, and the phone call, were not admissible for that purpose. So it would not, the court did not consider it when deciding whether or not to hold Sean without bail pending trial. So in this case, like many others, we end up with a difficult choice. Do we try to increase the likelihood of having someone held for the victim's protection, but force the victim to go through the trauma and exposure of testifying? Or do we risk release by not calling them and not putting on relevant evidence in front of the judge? And this is all occurring within 2 weeks of, or maybe just several days after what very well may have been the worst day in that victim's life. They may be.
Dana,
Yes.
Can I ask you a question about, while we're on this topic? I'm sorry to disrupt your flow here.
No.
Since we're talking about it. Regarding victims of domestic violence testifying so soon after an alleged assault, do you have any input or knowledge about the reliability of that testimony when it's so soon after the incident? Or should I ask that question to the network?
That may be better posed to the network. I think that I'm very familiar with the research about in-court testimony very soon to the events, exasperating PTSD symptoms. But I don't know if there's been any research about reliability.
Okay. Thank you.
So someone who has just been victimized in a domestic situation may be navigating, their abuser may have been their only source of income. They may be navigating the shelter system. They may be trying to figure out what to do with the children. They may be still physically healing from the assault. And we end up sitting down with them and telling them if they don't go into a room with their abuser, we have a greater likelihood of that abuser being released. And that's what, in my experience, victims of domestic assault are actually afraid of. They're not afraid of cross-examination. They're afraid of being in the room with their abuser 2 weeks after the event and having to talk about the event. And we have to tell them that even if you do testify, there's no guarantee that the court will hold them anyways. They may release them, and you may have just exposed yourself and have them be released. So in the event they are held, a trial is going to occur within 60 days. They have a trial right to have a trial within 60 days. Because of court scheduling, I've done a trial within 34 days after the assault to make sure that someone's 60-day trial right was fulfilled, because there was nothing between the 34-day mark and the 60-day mark. And during that time, they can be deposed, and they will be testifying at trial. So this is really just eliminating one of the multitude of times a victim's going to have to live in person tell what happened to them. It's using their sworn statements, their statements they swore to establish those prongs. It's not going to lessen the state's burden. I heard the question about this would allow in any types of evidence, and I think that while the rules of evidence don't apply, it would not mean that any evidence would be admissible, because one, the case cited by the senator, I think would keep out some evidence because there's a constitutional liberty interest. But also, any evidence would not necessarily be would meet the state's burden. It's still an extremely high burden. This is just about what evidence the court could consider. So, for example, the court could, if we had medical records that established that right after the assault, the victim's arm is broken, that might be some evidence that could come in to establish serious bodily injury without having to call a doctor in on short notice to establish that. It also brings uniformity to how these hearings are being conducted across the state. Some judges have ruled that the rules of evidence don't apply, and it would bring uniformity between the different bail statutes. But I think it's going to, most of all, provide victims of domestic violence a small measure of protection in a system that, frankly, largely disregards their needs and wishes throughout the process.
Thank you. So I do just have a few questions, Dana, and thank you for your testimony. So I just want to confirm that the victim can later be deposed, and they will also still have to testify once you get to the trial phase, and the rules of evidence do apply in those situations, right?
Yes, I mean, the rules of evidence don't strictly apply in a deposition, and the deposition is going to be conducted by defense counsel, but because there's a little more leeway in what questions they can ask. But there's going to be 2 times within that 60 days where they're offering sworn testimony, or potentially going to offer sworn testimony.
Thank you. And I'm going to make it a habit to ask everyone this question when we start dealing with changing these types of things here. Can you speak on how this may or may not affect the backlog? Will it make it worse? Will it make it better? Or is there no opinion on that?
So a defendant when they're held without bail under 7553A has a 60-day trial right, which means if the court cannot schedule a trial within 60 days or the state needs a continuance for any reason, they are entitled to release. So I don't know exactly how it'll affect the backlog. I don't think it'll affect, it won't cause lengthy pretrial incarceration because of that 60-day trial right.
Thank you. And Senator Baruth?
Thank you. I found your testimony very helpful. My question, because I think I understand the idea of aligning the various hearings. I understand, I think, the emotional context that we're dealing with the victim. But I don't know if you have the bill text in front of you.
I'm very familiar with it.
Okay. On page 2, the operative part of the bill is the first sentence of subsection B, information stated in or offered in connection with any order entered pursuant to this section need not conform to the rules pertaining to the admissibility of evidence in a court of law. I think I understand that that's necessary because you're dealing with a kind of binary admissible, inadmissible thing. And so this sentence is making everything admissible that was inadmissible. Are there any potentially unintended consequences from the broadness of that language?
So a court still has the inherent ability to control what's coming into evidence. So if, as an extreme example, if I offer a napkin with some scribbling on it and say, this is the victim's mother saying she's scared, that's not, I don't think a court would admit it, first of all, but I also don't think, even if something's admissible, that doesn't, it doesn't change the burden that the state needs to meet. It just changes what we can get in front of the court to make that consideration. But things that are not reliable, a court, even if they admit it, are certainly not going to weigh very heavily. And we will not meet a clear and convincing standard with bad evidence. I think that's the concern, is we're getting bad evidence in front of the court, and we just won't meet the clear and convincing standard with that type of evidence. We need compelling evidence that shows a fact is highly probable in order to meet that clear and convincing evidence standard. So I think this will largely, I think it's the broadness of the language is necessary because there are a lot of things. Like, I think that when we get medical records, there's not a lot of argument that those are necessarily unreliable, that there's a diagnosis of a broken arm. But that's not a sworn statement. It's not an affidavit, nor is it in court testimony. So it gives the court a lot more flexibility, but our very high burden, remains the same.
Yeah. Okay, and I'll just follow up by saying, my question really boils down to, is the broadness of this language necessary, or could a more targeted statement where you said the list of things that we've been discussing, affidavits, et cetera, articulating those and making those admissible, but this obviously makes the spectrum of things, including your napkin, admissible. It's just putting the burden on the court to sift through that now admissible evidence. But I think I understand what you're saying, which is in all other hearings, the judges are making those considerations. This would just align with that, and they would be making considerations as to the weight they want to give each piece of evidence now admissible.
I would say that I don't think it would make anything admissible. I think it still needs to be relevant, and there still needs to be some reliability to the evidence under the case law, because it affects. So unreliable hearsay under the case law cannot be used to when in a hearing when it affects someone's liberty interest. So it does not make everything admissible, but it doesn't.
I'm just struggling with the language though, because it seems like that sentence does make everything admissible. It says the rules of admissibility won't pertain. So I don't, once that sentence is passed, it seems like everything is admissible and we're just sifting through it. You know? Well,
the Constitution will still eliminate certain evidence based on the case law, and it's just saying that the rules of evidence are not applicable.
Okay, fair enough. Thank you.
Dana, just quick reiteration here. In your experience, are there judges who are currently operating in such a way as if this bill is already in effect regarding the rules of evidence?
Yes.
And
yes,
actually I'll just leave that there. And okay, actually, yeah, that's all I have. Thank you. Any other questions? Ben?
Not a question, but just a point of clarification on the case law. So in that case, State v. Lesage, I mean, what the court opines on is that in other proceedings where the rules of evidence don't apply, and hearsay is introduced as an example, there are certain safeguards in effect to protect a defendant's constitutional rights. For instance, Rule of Criminal Procedure 4B permits the court to rely on hearsay evidence if finding probable cause, if there is a substantial basis for believing that the source of the hearsay is credible, and for believing that the factual basis for the information which is furnished. Or there's a case law also saying that you can admit hearsay evidence when good cause exists, which requires the court to consider the reason offered by the state for not offering live testimony and the reliability of the hearsay. So that's that liberty interest balancing that the Constitution provides. So there's still that sort of self-policing, for lack of a better term, that the court does for that type of evidence.
Yeah.
Thank you, Ben. And I think just a comment to your point, Senator Baruth, I think, if we want to, we could talk about adding language to say that this second section could proceed under conditions of release evidentiary standards, which is located in 7554 B1 and 2. And then there's also the caveat that the rules of evidence don't apply to those same things, but if that makes it a bit better.
And, you know, to be clear, I'm in support of where we're going. And clearly drafters pick different things, often using terms of art. So it may be just that the words admissible and inadmissible to a layperson seem overly broad, but as you point out, there are belts and suspenders elsewhere, including constitutional rulings. So I defer on that point, but it does, you know, at first blush, it seems like a pretty, painting with a pretty broad brush.
Yeah, and that was also my question I've asked a number of times just to make sure I fully understand it regarding, because it did feel initially quite broad, and that's why I did a deeper dive into that, but yeah.
And just as far as a drafting consideration is concerned, you know, obviously the committee is free to request whichever language, but sort of, you know, Deputy Attorney, Defender General Paul mentioned before on the last bill that when you put in language that might differ, there might be an implication associated with that. Well, why is it different in 7553A than it is in 7554 sub G? So that's just something to keep in mind. And then also there was, Senator Sheen, you're part of this conversation. There's a broader conversation about where to locate this language specifically. Because in 7554, it specifically excludes 7553 and 7553A from that analysis. So that's why there's not a cross-reference to 7554, since it would require a broader revision of 7554. However, that seems to potentially be on the table in some other bills. So just to kind of keep that in mind when we are crafting the language and where we go.
Thank you. Anything else from the committee? Anything else from you, Dana?
No, thank you very much.
Great. Yeah, thank you for testifying. All right. All right. Next up, we have Marshall.
It's good to see you again, Marshall.
Good to see the committee again.
It's been a while.
It's been a while. Thank you very much. We wholeheartedly oppose this bill. First of all, we disagree with the sort of presumption that there would be guardrails in place. This bill says that the rules of admissibility will not apply, which essentially puts it in the same exact category as 7554. And I want to talk about the difference between those two, because I think that's very important. 7554 is when you are in front of a judge and you are going to, the judge is considering how to release you. It's not, the judge is not considering how to hold you without bail. The judge in a 7554 analysis can only be considering what conditions of release should be applied in order to ensure your appearance, what conditions of release should be applied in order to ensure public safety. When you're talking about 7553, you are talking about hold without bail, which is one of the most drastic things that our judicial system can do, to incarcerate somebody before they've been found guilty. It's in fact something that wasn't even considered legal until the late 1980s, when the US Supreme Court ruled in United States v. Salerno that it was actually permissible to incarcerate people pre-trial for public safety reasons, as opposed to only for flight reasons, which had been the holding up until that point. But the US Supreme Court said in Salerno that in our society, liberty is the norm, and any detention prior to trial or without trial is the carefully limited exception. And that's because of the consequences of it. Holding people without bail ruins their lives. When you hold someone without bail, they lose their job. I've had clients who have been divorced while they've been held without bail. They lose contact with their family. It disrupts their employment. It harms their mental health. It harms their access to health care. I submitted to the committee assistant, and it should be on the webpage, an article from Vermont Public that was written less than a year ago regarding hold without bail, and how The instances of people being held without bail for long periods of time have increased as the pandemic and the backlog have gone on. That article was about a man who was held without bail for 18 months, actually, in Windham County in a domestic violence case. Was held without bail for 18 months before he got his trial, where he was acquitted. In that time, he lost his job, he lost his connections to the community, and he ultimately moved out of state. And at the end of the article said he was never coming back. That's the consequences of hold without bail. That's what we're talking about. We're talking about people who are often held for extended periods of time without trial. And to say that we are going to do that without applying the rules of evidence at all, from my perspective, is kind of absurd, because the rules of evidence, go ahead.
I'm sorry to interrupt you. So I just want to make sure that we're talking about the same thing. So somebody being held for 18 months, that would fall under 7553. Was it under 7553?
I would have to figure that out. It was either, I can't tell the difference from the article.
Because for this bill, it's solely for 7553A, which has the 60-day limit. And from what I understand, after the 60 days, that person gets released, right?
That has been the practice if the Supreme Court intervenes. There's been cases where people have been held longer than 60 days on 7553A. It certainly happens.
Okay.
I'm not saying it should, but it does.
Okay.
And in addition to that, 60 days is still, you've lost your job, you've lost your housing, you've lost your connections to your service providers, if you have any. 60 days of holding someone without bail is still a very drastic action by the judiciary.
So I'm not disagreeing with that, with what you're saying, but I think that the substance, though, is what type of evidence, or actually maybe you're getting to it, so I don't want to get ahead of myself.
And I
here,
think that's what I'm getting to next, is that the rules of evidence are designed to ensure that courts rely on accurate evidence in order to make their decisions. And the rules of evidence are honestly not hard to follow. Basically, the rules of evidence break down to sort of four things. Foundation, can someone explain where the information is coming from? Authentication, can somebody explain that the evidence is real? Relevance, can somebody explain that the evidence is relevant to the question before the court? And reliability, and information is presumed reliable, but there's some circumstances like hearsay exception, for example, where somebody has to explain why this evidence is reliable and should come in despite the fact that it doesn't satisfy one of the rules of admissibility. To write a statute that says the rules of admissibility simply do not apply really would mean, as Attorney Nevins said, that you could introduce a napkin with scribbles on it, and we would be leaving it to the judge to determine what weight to give to any bit of evidence. Literally anything could come in. And I agree that probably the Supreme Court would put guardrails on it, as they do, for example, in a probation case. But those guardrails are extraordinarily limited. They're basically the 14th Amendment and the 14th Amendment alone. And so what the Supreme Court has held in those cases is, anything is admissible as long as there is some indication of reliability. That's not a strong enough standard to support holding people without bail, given the consequences of that. I would say that this bill is really inconsistent with the U.S. Supreme Court's decision in Salerno and with our own court's decisions regarding the degree of evidentiary certainty that it is required to hold someone without bail, and what type of hearing and what type of access to the evidence people have to have. In Salerno, one of the reasons that they said that it was permissible to hold people for public safety reasons is because they were given a full-blown adversarial hearing with full rights of cross-examination. Now, you can't have a right to cross-examination if your evidence is coming in through hearsay, if it's coming in through a piece of paper that's admitted simply because it's a medical report and there's no doctor there to testify as to its foundation or authenticity.
So But the ability to cross-examine does occur when you get to the trial phase though, right?
Certainly, but that's not what Salerno was talking about. In Salerno, they were saying, we're permitting the idea of holding someone without bail for public safety reasons because that hold without bail decision, they were testing the Federal Bail Act of 1984, and they said it was permissible because that act provided such robust evidentiary protections because it required a full-blown adversarial hearing with full rights of cross-examination. So I would also say, well, I'll leave it at that and take any questions. Oh, one other thing I just want to mention is this, from my perspective, this bill just lowers the standards for what it takes to get somebody held without bail under 7553A. If this bill passes, we are likely to have a lot more people held for less accurate reasons. I mean, the point of the rules of evidence is to ensure accuracy. And if we're no longer ensuring accuracy, if we're saying sort of accuracy is out the window, it's more about, protecting the victims from having to testify and ensuring that, these things happen quickly, we're going to end up with more people being held. The current number as of a few days ago is we had more than 400 people held pre-trial in Vermont. That's, I've forgotten what that was as a percentage of our total inmate population, but it was something nearly 30%. Nearly a third of our population was pre-trial detainees. And to suggest that we're going to increase that number and do so with less accuracy when we've already identified in years past with outside expertise from Center for State Governments that we're actually holding too many people pre-trial in Vermont, to me seems like really steering in the wrong direction. And honestly, from my perspective as someone who deals with these situations on a regular basis, it's just not that hard to follow the rules of evidence and ensure that you have someone there who can authenticate your evidence, ensure that you have someone there who can provide a foundation for your evidence. And from my perspective, that should be a bare minimum requirement if the states can exercise what's really an awesome power, which is to lock someone up before deciding whether or not they're guilty or innocent.
So from what I'm understanding is that currently there's a lack of clarity as to whether the rules of evidence apply to the second part of 7553A hearings. And I think that I'm just trying to think of what my question is here, but so the rules of evidence currently don't apply to any other bail hearings, right?
The rules of evidence do not apply to 7554 bail hearings. Those are hearings about release, not about hold without bail.
Do they also apply to 7553 hearings?
I'd have to think on that and do a little bit of reading. That
Okay.
It was not the question I was prepared for.
Okay, because from what I was looking at, and sorry, I wasn't trying to ask a question to which I already know the answer, as I believe they don't apply to 7553 hearings. So the thing that and if I'm wrong, please end up correcting me, but the thing that I'm trying to reconcile is why should the rules of evidence sometimes apply, depending on who the judge is, sometimes apply to the second part of 7553A hearings, but they don't apply to 7553 hearings.
And if they don't apply to 7553 hearings, I think they should. I mean, when we're
Fair.
talking about holding someone without bail, I think that is a decision that, as I said, courts make that decision about, we have about 400 and something people being held pre-trial. When it comes to hold without bail, that's actually a very narrow category. It's not a decision that judges have to make very often. It is a decision that should be made with the utmost accuracy. We should be ensuring that we are not holding people without bail who do not need to be held without bail, because when we hold them without bail, we're ruining their lives. And I think that that Vermont Public story that's on the committee's webpage really does a great job of sort of telling the story of how that can happen and how that can really lead to substantial disruption in someone's life, someone who's innocent.
Thank you. You folks have any questions? Oh, looks like you're thinking.
I am.
I forgot to ask, backlog, any thoughts on that? I'm trying to ask everybody that question now for when we're making changes. Any initial thoughts or?
Again, when it comes to so I really think the backlog is a problem, and I want everything to be done to address the backlog. There are things where I think that are more important than the backlog. And I think hold without bail is being one of the most drastic things that the court can do, involving as it does incarceration prior to a determination of guilt or innocence. I don't think the backlog should be a question. These are among the most important and consequential decisions a court can make, and we need to give courts every tool to make them as accurate as possible, whether or not that makes a hearing take a little bit longer or not. I wouldn't say that. I mean, the reason why the rules of evidence don't apply in 7554 is because the consequences are so much less great. It's a statute about release. It's not a statute about, guiltless incarceration. And to me, that makes all the difference in the world. 7554, the consequences are not as great. The rights to appeal are very solid, and it's a statute about release. And so there's no reason not to, in that case, speed up the process by allowing sort of proffers rather than evidence. In 7553 and 7553A, where we're talking about holding people without bail, despite the fact that they are innocent, that should absolutely require evidentiary precision.
Thank you.
Thank you.
That hasn't processed enough.
Thanks, Marshall. Judge Zone, I want to make sure you have a good amount of time. Are you good?
As much or as little time as you would like from me.
Okay, I think we're hoping to adjourn at 12, but
That means I've
that
got
works.
5 minutes.
Oh, and if you want to come back, we're happy to have you for longer.
Good morning, Tom Zone, Chief Superior Judge. The proposed statute, as has been identified by the prior witnesses today, essentially addresses what the federal courts is called a split the circuits. There are some judges who see it one way and some judges who see it another, and this clarifies how the legislature wants to go forward as a policy. It is correct that irrespective of what the language is, any language that any statute contains has to be in accord with constitutional protections. And so you've mentioned Senator Hashim about the Lesage and other cases, and we've heard about Salerno. Whatever the constitutional protections are that would apply, that would have to be something that the judge makes sure it occurs. One comment I would make about the proposal is that when you look at the language, it says, it starts off, information stated in or offered in connection with any order entered pursuant to this section. And then it goes on to basically pull in the 7554 language. And then the second half says, nothing in this subsection shall be construed to alter the existing standard. I know what you're trying to get at, I believe, which is you don't want to affect the evidence of guilt being great part of the statute. But the statute has 3 separate and distinct components. The first is the state has to establish the evidence of guilt is great under Vermont law. The second is that the state has to establish that by clear and convincing evidence that the person's release poses a substantial threat of physical violence to any person. And the third is that no condition or combination of conditions will reasonably prevent that violence. And so it seems to me that if you're putting the first part of the first sentence to say that the rules of evidence essentially don't apply in any order, And then the second half, you're going, well, nothing affects the first part. You're building in somewhat of an inconsistency. And again, I know what you're trying to get at, and I would suggest if you're going to go forward with this as a policy decision, that you might want to consider just restructuring the first sentence a little bit to say information stated in or offered in connection with determining whether the person's release poses a substantial threat of physical violence to any person, and that no condition or combination of conditions of release will reasonably prevent the physical violence, need not conform to the rules pertaining to the admissibility of evidence in a court of law. And then if you left the second sentence alone, that stands on its own. But you're highlighting in the first sentence exactly what you're trying to accomplish here, to remove any questions about, do the rules of evidence apply to the first half? If you wanted to keep the first sentence the way it's currently worded, I would probably change the word nothing in the second sentence to say notwithstanding this subset, notwithstanding this, nothing in the subsection. You need to, I think, identify it further. Beyond that, if there's any questions, I'd be happy to address them.
Thank you for your testimony. With the remaining 2 minutes, could you talk about the backlog and if you have any opinion as to whether it'll affect it in any direction or
If
not?
there are cases where a judge is currently determining that the state has to present live witness testimony, and those cases take 2 or 3 hours, then if this statute were passed, that 2 or 3 hours, it might not take as long. It might be a much shorter hearing. And so if you're only taking 1 hour for a hearing like this, as opposed to 3 hours, I would say that provides an opportunity for courts to address their backlog.
Okay.
But I would also note that this says the state is not obligated to present live testimony. It doesn't prevent the defendant from subpoenaing the putative victim in a case to have to come to court to testify.
In the weight of the evidence here?
In the way of the evidence hearing. The statute does not say that the defense attorney can't subpoena a putative victim. It just says that the state is not required to introduce that type of evidence.
Okay, that's good information to know. So just a minute, I just want to make sure I understand it. If for a 7553A hearing, the defendant can subpoena the victim to testify in that hearing about the facts of the case.
That's generally what would happen oftentimes. And I was just looking at a case in the Supreme Court where the Supreme Court talked about the type of information that came in at the 7553 hearing, and that was affidavits, court records, recordings, and testimony. And so testimony can be offered by the parties. It also doesn't prevent the state. If the state can't get substantial admissible evidence by way of an affidavit, that would also allow the state to call the putative victim to testify at the hearing to establish that crime. So the parties still can call witnesses.
Thank you. And last question, I promise. Do the rules of evidence apply to 7553 hearings?
I think that many judges would take the position they don't. I can tell you that there was a case that the Supreme Court issued years ago where they talked about what's called State v. Breer. I believe it was a 2014 case in a bail decision. I believe in paragraph 10, the state talked about the fact that I'm sorry, I'm going past 1201. And what the court said was, even when a defendant may be held without bail, the trial court retains discretion to grant bail, and its discretion is extremely broad in making this determination. Under 13 VSA 7554B, there are several factors for the court to consider in deciding whether to grant bail and under what conditions. Here, the trial court expressly contemplated those factors. And so I point that out because it seems as though the Supreme Court has recognized that 7554 does have a place within 7553. And I think, I don't know how other judges would see it necessarily, but I do know some judges do not apply the rules of evidence in that determination.
Thank you.
Much like the split that we're seeing in 7553A.
Got it. Thank you very much. Senator Norris, I know you had a question, right? I'm just kidding. Thank you, Judge.
Thank you.
Yeah. At what point in time would you let me get up and break up the quorum?